I'm here at the Securities and Enforcement Forum in Washington, D.C. with Andrew Ceresney, who is the Director of Enforcement for the U.S. Securities and Exchange Commission. Andrew, thank you for joining me. I want to start with a bit of a general question, and then we can move into some specific topic areas. You've been in your post now at the SEC for just over 3 years. I guess I'm curious.
3.5 years.
3.5, all right. I guess I'm curious, what is the biggest change you've encountered in bringing enforcement cases in your tenure in general?
Sure. Well, it's been a really busy 3.5 years. We just announced results for last fiscal year just the other day, and we had another record year, 868 total enforcement actions, 548 standalone actions. Very active year with really significant cases like the Cooperman insider trading case, the Walters insider trading case, lots of FCPA cases, including the OXIF case, and so really significant cases. And so, I look back at my tenure at the SEC, and it's been a really eventful time. I feel like some areas where we've made great progress include our use of data. We've really enhanced our use of data in lots of ways, just tremendous amounts of data now available. We've developed tools that allow us to detect misconduct and then investigate more quickly. I think we've enhanced our litigation capacity significantly. We've done very well in district court, and I think we're really a force to be reckoned with when we take cases to trial. And I think if you look at the industry impact of our cases, they've had a tremendous impact. I just point to a couple of areas like private equity, the municipal area, which I'm going to talk about today at the Enforcement Forum. Just really huge impacts on those industries. And then, sort of look at morale in the Enforcement Division, I think has been enhanced significantly. That's agency-wide. Mary Jo has done a great job with morale, but also in the Enforcement Division.
Now, you mentioned among the cases, you mentioned insider trading. There was a big oral argument at the Supreme Court last week about what kind of liability there is, or what there has to be for liability for the first person to kind of disclose inside information. And circuit courts have come out different on this. What did you think of that oral argument, and how has the insider trading landscape changed in the cases that led up to that case?
Sure. So I've listened to the argument. I wasn't present at the argument, but I've listened to it. And my hope, and the argument I think suggested this, is that the Supreme Court in the Salmon case upholds basically Dirks, which was an earlier case on personal benefit, the definition of personal benefit. To me, the important thing is that the court find that both quid pro quo is sufficient to establish personal benefit, but also intent to benefit. The tipper intends to benefit the tippee. I think when you look at the last couple of years post-Newman, most courts have interpreted personal benefit to include intent to benefit. And so therefore, because that's included in personal benefit, I think most cases will involve either quid pro quo or some intent to benefit. That is, the tipper knows the tippee is going to trade and wants them to trade. And I think that, I think post-Newman, it hasn't had a tremendous impact in that respect. If you look last year, we brought 78 actions against 78 individuals for insider trading, which was, a pretty strong year. And then the real impact of Newman, longer term, is really on the remote tippees, on the fact that Newman held that the tippee has to know that the original tipper received a personal benefit. That becomes harder as you get farther down the tipping chain. So those are the cases where I think we faced a little bit more of an issue.
Well, we're all watching the insider trading cases intently. In your first answer, you mentioned a little bit, changing gears here, industry impact on what the Enforcement Division's been up to. So how have you seen that poured over in the whistleblower arena? The SEC is very much active in promoting these big numbers of whistleblower payouts, and are you seeing in the course of your investigations that is trickling down into the industry and they're taking account of it?
Yes, the Whistleblower Program has been very successful. We passed the $100 million mark in terms of awards this year, which was very significant. And we continue to pay out awards over time. We had a record number of tips this past year, which I think also shows the program is getting the public acknowledgement that it should. In terms of industry impact, I think it's had a significant industry impact. I think many companies are now much more sensitive to the issues. They have internal compliance program, which allows internal reporting. We try to encourage internal reporting a couple of ways. We give people credit for information that the company provides to us if they also report to us and to the company. And we also take into account reports to the company as a positive factor in enhancing the level of the bounty. So we try to encourage that. When you look at our last year's whistleblower report, 80% of the cases in which the whistleblower was an internal employee, they actually reported to the company as well as to us, and that's a positive thing. So we think that that's positive. We're also trying to encourage that kind of internal reporting and discourage retaliation against whistleblowers through. We brought our first standalone retaliation case just a couple of weeks ago, and we've also brought a number of cases under 21F17, which precludes companies from taking actions to impede a whistleblower from communicating with us. And we brought a number of those cases in this past year on different factual scenarios. But those are important cases because they encourage people to come to us and discourage companies from trying to impede them.
And there are some federal circuit court cases that are playing out over whether, what does a whistleblower have to do to qualify for some of these anti-retaliation protections. And we're all watching that too. But I want to talk about accounting a little bit too. We've heard Chair Mary Jo White say that the agency is looking to kind of crack down a little bit on disclosures that are too reliant or deviate too far from generally accepted accounting principles. What is the Enforcement Division's role in heeding that call, and are there cases coming that we can expect on that?
Yes, and Chair White has spoken about this a number of times. OCA, the Office of Chief Accountant, and Division of Corporation Finance are very focused on these non-GAAP issues. We in enforcement also have investigations of non-GAAP issues out there, and we're focused on that issue as well. I would point to the American Realty Capital Partners case we brought over the past year, which involved an important non-GAAP measure in connection with REITs, and that's just an example of a non-GAAP case that we brought. I think you'll see additional activity in the future in this area in enforcement as well.
Okay, and last thing I'd like to cover with you, Foreign Corrupt Practices Act. We've seen, you alluded to this a little bit in your first answer too, but we've seen in recent weeks a couple of big cases on that. You think of the Credit Suisse and OXIF, excuse me. Are we going to see more of that? What is the message that is trying to be sent there?
Well, this was a record year in FCPA actions. So we brought 21 actions, which is a record number in terms of what we brought. We had important cases like the VimpelCom case, which was almost $800 million, both to us, DOJ, and the Dutch regulators. The OXIF case was a critical case. It involved both $400 million plus for the entity and a guilty plea by a subsidiary, as well as charges from us against the CEO and CFO, which is the first time we've charged the CEO of a financial institution with FCPA, with books and records violations relating to an FCPA case. And so those were critical cases. We've also brought a number of cases in the pharma industry, a result from a sweep that we did there. We brought a number of hiring practices cases, which are important cases. So there's really a lot of activity in that area. We've also focused on individuals. We brought this past year 7 cases and deferred prosecution agreements relating to individuals, and those were important cases to bring. And the other sort of development in that area is the international cooperation. When you look at the cooperation we're getting from foreign countries, it has increased exponentially. An example of this is the VimpelCom case. When you look at our press release in that case, there are 14 different countries that we acknowledge in the press release as providing assistance in that case, which is really just a huge sea change and really a great thing to see. So I think you're going to see more activity in that area in the coming years, and I think it's an important area for us to be in.
Well, I want to thank you for your time. We've covered a lot of ground in not a lot of time. I've been speaking with Andrew Ceresney, Enforcement Director of the Securities and Exchange Commission, here at the Securities Enforcement Forum in Washington, D.C.